Ladies and gentlemen, welcome to tonight's debate. My name is Rebecca Lanzilli and I am the chairman, and Yuran Jiang is the timekeeper. This debate will be judged by a panel of 3 judges who are Mr. Barrett, Mrs. Salom and Mr. Wan Kichu. The topic for tonight's debate is that the national age of criminal responsibility should be raised to 14 years. The affirmative team seated to my right is from Concordia College, and the negative team seated to my left is from Glenunga International High School. The speaking time for this debate is 5 minutes, with a double bell at the end of your speaking time. A warning bell will ring once at 4 minutes, and a continuous bell will ring 30 seconds after the final bell. Please switch off your mobile phones and other electronic devices. I now declare this debate open. I call upon the first affirmative speaker, Sophie Lim.
Good evening, Madam Chairman, ladies and gentlemen. The topic for our debate is that the national age of criminal responsibility should be raised to 14 years. We define the topic as the national age of criminal responsibility across all Australian jurisdictions. Currently, according to the Parliament of Australia's Department of Parliamentary Services, a child under 10 years cannot be found guilty or held responsible of a criminal offence. 14 years refers to an individual who is over 14 years and 0 months at the time of the alleged offence, according to the Gregorian calendar and as defined by the Cambridge Dictionary. We, the affirmative team, believe that this statement is true and the age a child can be held responsible of a criminal offence in Australia should be raised from 10 to 14 years old. As first speaker, I will be arguing 2 points. That children under 14 years are incapable of determining what is criminally right or wrong, which follows the common law of Dolly Incapax, and that the minimum age of criminal responsibility in Australia is low in comparison to other countries. Our second speaker will be arguing that raising the national age of criminal responsibility to 14 years will lower the incarceration rates of children and that young offenders can get the care they need. Our third speaker will rebut and sum up our team case. My first argument is that children under 14 years of age are incapable of determining what is criminally right or wrong. This follows the fact that Australia's laws are based on the common law, according to the Australian Human Rights Commission. Common law has a principle known as Dolly Incapax. This term, Dolly Incapax, comes from the Latin incapable of deceit, which essentially means that under the common law, a person younger than 14 years old is considered incapable of knowing what is morally right or wrong. The Law Council of Australia states that Dolly Incapax is extremely difficult to apply in court, and depending on the lawyer and judge, some young people may receive a favourable outcome over others for the same crime. This creates injustices in the legal system. Raising the age of criminal responsibility to 14 would remove the need for courts to consider the confusing and complex Dolly Incapax presumption. Furthermore, research on brain development from Raising Children Network clearly shows that the brains of young people under 14 are not fully developed and have only just begun to develop critical and abstract thinking skills, which means they are not yet fully capable of understanding what is morally right and wrong. In raising the age of criminal responsibility from 10 to 14 years, it should be done so because children under the age of 14 are not only considered Dolly Incapax, lacking the capacity for criminal responsibility, but have also not developed the intellectual and moral maturity needed for full criminal intent. So, This is why we, the Affirmative team, strongly believe that the national age of criminal responsibility should be raised to 14 years. My second point is that the national age of criminal responsibility should be raised to 14 years because the age of criminal responsibility in Australia is low in comparison to other countries. In 2019, the United Nations Committee on the Rights of the Child recommended that all countries increase the minimum age of criminal responsibility to at least 14 years of age. Some of these countries with higher ages of criminal responsibility include New Zealand at 14, Japan at 14, Finland at 15, and Norway at 15. Notice how all these countries have a national age of criminal responsibility upwards of 14, while Australia's is still currently at 10. This links back to what I explained earlier about Dolly Incapacts, where the Committee on the Rights of the Child specifically urged the Australian government to raise the minimum age of criminal responsibility to an internationally accepted level and make it align with the upper age of 14. During the United Nations Universal Period Review Working Group session, a whopping number of 31 countries recommended that Australia raise the minimum age of criminal responsibility. This widespread support from international bodies shows that Australia's current age of criminal responsibility is too low compared to other countries. So, Madam Chairman, ladies and gentlemen, in conclusion, we, the Affirmative team, absolutely believe that the national age of criminal responsibility should be raised to 14 years. Thank you.
I now call upon the first negative speaker, Kashmira Roy.
Good evening, Madam Chairperson, ladies and gentlemen. The topic for tonight's debate is that the national age of criminal responsibility should be raised to 14 years of age. We agree with the definition given by the Affirmative team. However, we, the negative team, strongly believe that this statement is false. The first Affirmative speakers tried to say that Australia has a lower national age of criminal responsibility than other countries. However, just because other countries have this law does not mean that we should too. Tonight I'll be talking about 3 points. My first point addresses the proposal of an alternative model. Although the welfare of the youth is undeniably important, raising the age of criminal responsibility to 14 does not solve the underlying issues. Conversely, we propose an alternative model of raising the age from 10 to 12. This approach acknowledges the fact that 10-year-olds may lack the cognitive ability to be fully aware of their actions, whilst ensuring that older children and adolescents remain accountable for their behaviour. A study by the National Institute of Health shows that at age 12, children typically have a more developed understanding of the implications of their actions, making this change more reasonable. Moreover, increasing the age to 12 instead will allow for early interventions and mental support for socio-economic insecurities or familial environmental issues which may drive their behaviour. However, raising it to 14 will make it near impossible to influence their behaviour through interventions such as juvenile, as children will have already developed a majority of their personality, including their perception of right and wrong. It also encourages adolescents to act irresponsibly, knowing they would be protected from any penalties, even for serious offences. Thus, it is critical to raise the age of criminal responsibility to a more suitable level to ensure the safety and well-being of the public, and that children are taught a sense of morality and accountability for their actions. My second point is about how this judicial leniency increases the risk of repeated offences. According to the Sentencing Advisory Council, approximately 51% of youth offenders with no prior convictions have reoffended. If the current age for criminal responsibility is raised to 14, This will only increase the irresponsibility among the youth as it allows them to reoffend without any form of repercussions. This judicial leniency will consequently lead to adolescents feeling entitled to commit more serious crimes without fear of immediate consequences, further endangering the public and making them feel unsafe in their own environments. A child's environment or upbringing are also some of the major crucial factors influencing their likelihood of committing or repeating offences. In fact, the Australian Institute of Criminology shows that 71% of juveniles have used at least one illegal substance in the 6 months prior to their committed offence, which is a direct effect of being in a negatively influencing environment. By placing the child offender away from their negative environment, including familial community, juvenile detention gives the children a chance to reflect in a more healthy environment which supports them instead of aggravating their motives. My last point is about how this change in law contributes to peer pressure, further increasing the rates of child offenders. As said before, children who are aged between 10 to 14 are highly susceptible to bad influences. This highlights the importance of enforcing these rules earlier, as it promotes the idea that people of all ages must take responsibility for their actions. Raising this age to 14 will lead to disregarding the law and will make children more inclined to commit crimes and join criminal organisations due to peer pressure and lack of fearing consequences for such actions. Early intervention reinforces the notion of consequences for illegal actions, thus allowing them to resist peer pressure and engagement in criminal activity. So, Madam Chairperson, ladies and gentlemen, to conclude, the national age of criminal responsibility should not be raised to 14, but instead 12, as it reduces peer pressure and the likelihood of repeated offences, promotes moral responsibility, and overall ensures the safety of the public. Thank you.
I call upon the second affirmative speaker, Keziah Chang.
Good evening. Madam Chairman, ladies and gentlemen. The topic for tonight's debate is that the national age of criminal responsibility should be raised to 14 years. We, the affirmative team, strongly believe that this statement is undoubtedly true. I will begin by rebutting the claims of the negative team. The negative team has tried to argue that the national age of criminal responsibility should be raised to age 12. This argument is completely illogical, because according to psychologist Jean Piaget, children at age 14 progress through stages of cognitive development with rapid physical, cognitive, and psychosocial growth, affecting how they feel, think, make decisions, and interact with the world around them. As well as this, enforcing what our first speaker has already said, the common law of Dolly Incapax, which states that children aged 10 to 14 should not be held criminally responsible, would be ignored, ripping the rights away from these children. This is why the national age of criminal responsibility should be raised to 14 years. Our first speaker has already rightfully argued that the national age of criminal responsibility should be raised to 14 years because children under the age of 14 do not have the capability of determining right and wrong. She has also expressed that the minimum age of criminal responsibility in Australia is evidently lower than in other nations. Now, to my points. My first point is that raising the national age of criminal responsibility to 14 years will lower the incarceration rates of children, including young First Nations people. According to the Australian Medical Association and the Law Council of Australia, the arrest of a child should always be a last resort for children. The Australian Institute of Health and Welfare writes that the younger a child is when having first-time contact with youth justice, it is more likely that the child will reoffend as a juvenile and as an adult. A criminal record is pinned to you for life. The Australian Human Rights Commission says that individuals with a criminal record are often denied employment and are typically harassed in work and school environments. Should one's life be set out like this because of something they did when they were under 14 years old? Moreover, statistics from the Productivity Commission tell us that Aboriginal and Torres Strait Islander youths are detained at a rate of 23 times that of non-Indigenous people. Raising the national age of criminal responsibility to 14 years will benefit Australia's young First Nations people who are overly and unfairly detained. My second point is that raising the national age of criminal responsibility to 14 years can help get young offenders the care that they need to prevent a lifetime of criminalized behavior. Faith Gordon, a law professor at the Australian National University, advocates that putting children in youth justice has a long-lasting consequences on their physical, psychological, and emotional well-being and development, which could lead them down a lifetime of criminalized behaviors. The reoffending rate, according to the Australian Institute of Criminology, for young people has been reported to be as high as 96%. Article 37 of the United Nations Convention on the Rights of the Child states that detention should only be used as a last resort, and further evidence states that instead of tossing them into the criminal justice system, providing essential support can help them become better people in the future. Rather than leaving these children with constant exposure to abuse in the justice system, severe mental health issues, and an unclear direction to a right way of life, alternate methods like social work, restorative justice, and mentoring would be able to teach them responsibility and guide them on the right path. If we refuse to change how to take care of criminal youth, it is the futures and well-being of children being denied to do better who will pay the price. So, Madam Chairman, ladies and gentlemen, in conclusion, we, the Affirmative team, strongly believe that the national age of criminal responsibility should be raised to 14 years. Thank you.
I call upon the second negative speaker, Tisani Dongali.
Good evening, Madam Chairperson, ladies and gentlemen. The topic for tonight's debate is that the national age of criminal responsibility should be raised to 14 years. We, the negative team, firmly disagree with this statement. Our first speaker has already explained how raising the age to 14 increases the risk of repeated offences due to this judicial leniency and the proposal of an alternate model of raising it to 12 rather than 14. The Affirmative team has tried to tell you that changing the national age to 12 is illogical. This is incorrect as 14-year-olds are often mostly progressed in terms of their emotions, meaning that they will be less impressionable and willing to change. 12-year-olds, on the other hand, are just reaching teenagehood, and entering a new environment will promote a healthy, active changes in their perspectives. Tonight I'll be discussing 2 points. My first point is that raising the criminal age of responsibility to 14 would significantly compromise the rights of victims and the pursuit of justice. This implementation would destroy the public trust with the justice system in the case of more serious crimes such as sexual offences, assault and robbery, as we risk denying victims and their families justice. From the Judicial Commission of New South Wales, the Honourable ACQC stated that confidence and trust in the judiciary does not require a belief that all decisions are wise or all behaviour impeccable. Confidence in representative democracy requires a belief that all politicians are enlightened and concerned for the public welfare. Regardless of the severity, victims of crimes deserve to see those who have violated them being held accountable. Raising this age can send troubling messages that youth offenders are exempt from facing legal consequences and can exacerbate the trauma experienced by the victims, which results in the perception the judicial system does not value their rights or needs, which is a crucial part of the recovery system as it provides a sense of security and closure. The current legal framework allows young offenders to be held accountable, whilst also considering age and capacity for rehabilitation. It also is heavily involved in protecting the rights of victims and offering young offenders a chance of redemption. However, if needed, raising the age of criminal responsibility to 12 rather than 14 allows a compromise between the current framework, whilst also integrating societal views. This ensures that those who commit crimes are given the appropriate and necessary interventions, which prevents reoffending, while still upholding the principles of justice for those harmed by their actions. My second point is that raising the age of criminal responsibility to 14 jeopardizes public safety by removing a deterrent for youth crime. This is significant to eradicate frequent and severe offences, endangering public safety and trust in the justice system's ability to maintain order and protect citizens. It can also foster a perception that crimes have no real consequences, undermining public trust and increasing fear and anxiety amongst communities. Without the action of legal interventions, many youth offenders who put the public at risk are unable to receive the crucial rehabilitation programs that are provided by the juvenile justice system. The justice program offered now does not only discipline, but ensures that offenders receive the proper aid, such as education and counselling, which can allow problematic behaviours being corrected to deter further complications. For instance, the Youth Justice Psychology Services provide psychological assessment and targeted intervention to identify and address behaviour of youth offenders. Furthermore, without intervention at a young age, negative mindsets can develop, in which they believe crimes can occur without repercussions, which is dangerous for themselves and others. This leads to a continuous cycle of crimes, and past minor offences can lead to more serious and harmful ones. Moreover, allowing the youth to commit crimes without consequences does not prepare them for the realities of adulthood, where actions are harder to control and rehabilitate. Overall, this sets up young offenders for a future of continued legal altercations. So, Madam Chairperson, ladies and gentlemen, to conclude, the national age of criminal responsibility should not be raised to 14 due to it compromising the rights of victims and the pursuit of justice and jeopardizing public safety.
I call upon the third affirmative speaker, Adele Chapman.
Good evening, Madam Chairman, ladies and gentlemen. The topic for our debate is that the national age of criminal responsibility should be raised to 14 years. We, the affirmative team, absolutely believe that this statement is true. I will begin by rebutting the flaws in the opposition's case. The negative team has argued that raising the age to 14 would allow crimes without consequences. However, this is false, as raising the age of criminal responsibility doesn't mean there is no consequences for harmful behaviour. Instead, it shifts the focus from punishment to rehabilitation for these young children. By addressing the root causes of a child's behaviour through alternative methods like support, counselling and education, rather than criminalising them, we can prevent reoffending and ultimately create safer communities. And this is why we, the affirmative team, absolutely believe that the national age of criminal responsibility should be raised to 14. The negative team has tried to argue that we need to separate these children from their environments and place them in prison, which is a positive environment to allow them to change their behaviour. However, have we considered the long-term impacts of incarcerating children aged 10 to 14? Exposure as a young child to older children in prison can have a detrimental impact on a child's future. Rather than being influenced by positive role models like parents, guardians, family, support workers, social workers and teachers, these children are now influenced by other children in incarceration who are only locked up for committing the worst crimes. Do we want our children being influenced by these role models? We have already specified that these children don't have the mental capacity to understand right from wrong. So why are we treating them like we do? Criminalising and incarcerating these children is not a positive environment to allow them. The negative team has tried to argue that this will jeopardise public safety. However, this is false, as research by many organisations, including the Australian Institute of Criminology, clearly demonstrates that criminalising children can actually lead to higher rates of reoffending later in life. For these children between the ages of 10 to 14, rehabilitation and care is a much more effective method to prevent reoffending, rather than exposure to the justice system, which most likely perpetuates the vicious cycle of crime and results in a higher likelihood to reoffend. This is why we, the Affirmative team, firmly believe that the national age of criminal responsibility should be raised to 14. The negative team has argued that raising the age of criminal responsibility significantly compromises the rights of the victim, who might not feel that justice has been done when young offenders are not held accountable. However, true justice is not just about punishment or incarceration, especially for younger people between the ages of 10 to 14, who can't fully grasp the consequences of their actions. How can it be a fair and just outcome when they didn't understand the consequences of their actions in the first place? This doesn't sound like justice to me. 10 to 14-year-olds are incapable of knowing whether their actions are morally right or wrong and are unable to engage in reasoned decision-making and consequential thinking, as supported by the points raised by our first speaker. And this is why we, the Affirmative team, believe that the national age of criminal responsibility should be raised to 14 years. I will now summarise our team's case. Our first speaker argued that Australian laws are based on Dolly Incapax, meaning that children under 14 are considered incapable of understanding right from wrong. She noted that the national age of criminal responsibility is low compared to other countries and highlighted the United Nations Committee on the Rights of the Child, urging for an increase to match the internationally accepted age of 14. Our second speaker emphasised that raising the age to 14 would reduce child incarceration rates and reoffence. She also argued that having a criminal record negatively affects a young person's employment and working life. She also argued that it would lower the incarceration rates of young First Nations people, and that raising the age of national criminal responsibility would help give children the care and support they need to properly develop and stay away from a life of crime. So, Madam Chairman, ladies and gentlemen, children belong in the playgrounds, not in prisons. They need support, not given sentencing, and in the classrooms, not in courtrooms. And this is why we, the Affirmative team, absolutely believe that the national age of criminal responsibility should be raised to 14 years. Thank you.
I call upon the third negative speaker, Anna Arnad. Good evening, Madam Chairperson, ladies and gentlemen. The topic for tonight's debate is that the national age of criminal responsibility should be raised to 14. We, the negative team, strongly believe that this statement is false. As the third speaker, I will be rebutting the opposition's points and summarising my team's case. The first affirmative speaker has tried to say that the age of criminal responsibility should be raised in order to diminish confusing laws such as the Dolly Incapax. This is wrong because if the brain should be fully developed in order for someone to be punished for a crime, then the national age of criminal responsibility should be raised to 25, the age where the prefrontal cortex officially develops. However, this is not the case, as many children are perfectly capable of distinguishing the right from the wrong. If not, they would fall under the law Dolly Incapax, stating that children should not be prosecuted unless it is proven by the judicial system that they are aware of their crimes. The Dolly Incapax law allows children with corrupted morals to gain the support they need in order to improve. That is, of course, if the child is proven to have the capacity to commit the crime. The Australian Bureau of Statistics states that in 2022, 48,014 offenders aged 10 to 17 proceeded against the police. Just because they aren't fully developed citizens of our society does not mean that they have no sense of justice, morality, or self-consciousness. We acknowledge that children should be protected in terms of the law, but not at the cost of societal safety. She also spoke about the overrepresentation of Aboriginal and Torres Strait Islanders in juvenile detention centres. Changing the national age of criminal responsibility will not diminish the overrepresentation of Aboriginal and Torres Strait Islanders in juvenile detention centres, as the ratio of them to people of other races will still be the same. As said by the Australian Institute of Health and Welfare, only 6.3% of the children within the detention on an average night were aged 10 to 13, 3.3% of which were the First Nations children, while 85% were aged 14 to 17, with 75% of the children out of that being Indigenous. Nevertheless, this topic surrounds the age of the inmates rather than the race, deeming this argument as invalid. The second speaker spoke about how studies show that children arrested before the age of 14 are more likely to reoffend as adults than those children arrested after 14. Children who don't undergo forms of consequences or punishment at all will be influenced to further reoffend in future situations. What we should be doing instead of focusing on their age is the environment they are surrounded by during their daily life. Being in an unsafe living situation has a greater chance to influence child criminals into further offences. As our first speaker mentioned, the Australian Institute of Criminology stated that 71% of child offenders had used at least one form of illegal substance in the 6 months prior to their crime, which is a direct implication of the negative effects which an unsafe environment has on children. She also spoke about how detention only causes harm to children and young people. Juvenile detention offers psychological support and rehabilitation to the children, specifically addressing cultural and family identity. Juvenile detention is designed with rehabilitation and improvement in mind, meaning that attempting to rehabilitate and educate a child is far more beneficial than leaving them unchecked in fear of them becoming increasingly immoral. The Juvenile Law Centre states that there are juvenile prisons, or rather schools, which prioritise the mental well-being and the healing of children. Moreover, not holding child offenders accountable for their crimes will support the impression that they would be able to inconsequentially break the law, almost encouraging them to act up in the future. The third speaker spoke about how being in juvenile jail around other child delinquents will influence kids further. Juvenile detention centres are highly monitored facilities, and child delinquents will have a greater chance of committing more crimes if they go unpunished. Furthermore, if these children were brought up in an unsafe or criminally active environment, then they'll be further influenced to commit crimes, especially through the manipulation of parents or other important figures in their lives. In summary, our first speaker introduced an alternative model of changing the national age for criminal responsibility from 10 to 12. She also spoke about the increased risk of crime due to judicial leniency and explained the notions of holding children accountable for their behaviour. Our second speaker spoke about the victims' rights and maintaining public safety. Overall, the national age of criminal responsibility should not be raised to 14 in order to maintain the balance and safety of our community. Promoting a safe country with a low crime rate means to promote a country with sufficient punishment for our offenders. Australia as a nation should prioritise the safety of their residents over anything, and simultaneously make sure that child perpetrators are provided with the support they need in order to grow as people. Thank you.
You can keep going, Chairman.
While the adjudicators finalise the results, there is no chairman's notices, but
Will you call us for the results now?
okay. I now invite Mr. Sell to come forward.
I'll deliver the feedback in this instance. Congratulations on a debate well done. Get to this stage in the season, it's put a lot of effort in to get to this point, so congratulations to both teams. Usually I wouldn't give feedback in these panel debates, but in this instance I will. I'll tell you who won and then I'll tell you why. So we've delivered the debate to the affirmative team unanimously. Congratulations. So why did the affirmative win? Well, firstly, they discharged their arguments effectively. They used evidence and sources and so on. But the bigger reason they won is that the negative team, you didn't actually argue in the you didn't argue in the negative. You argued for an alternative model as to what they were proposing. And unfortunately, I mean, we try to stay away from these models in debating aside, because what it ends up doing is it turns a philosophical debate into a policy debate. And your position, a lot of what your arguments were about was that we should raise the age to 12 rather than 14. And so half of your arguments were in effect agreeing that 10 is too young. So you're sort of shooting yourself in the foot in that regard. You know, just to illustrate the issue, what would be the problem in you guys arguing that 14 isn't good enough, but we should do it 13 and a half? You know, so that's why we try to stay away from these models, because you end up agreeing with a lot of their points and just proposing your own alternative theory. The other reason is that there was a lot of evidence missing. So whereas the affirmative had plenty of studies, there was very limited substantiation of your position. But look, again, these are sort of top-end teams, so you're going up against someone that's very good. Perhaps if this was a normal round, you would have won. But you know, it was a big structural issue arguing this model rather than addressing the point in the negative. All right, so that's that. In terms of the debater of the night, we've awarded it to Adele. So good job there. Congratulations. There you go.
I call upon a member of the runner-up team to give a vote of thanks.
I'd like to thank everyone for coming tonight. Thank you to the adjudicators for giving us feedback. Thanks to the timekeeper and chairperson. Thanks to the opposing team. You guys were like really talented with your speaking. And thanks for the audience for being here tonight. Yeah.
I now call a member of the winning team to second that vote of thanks.
We, Concordia College, would like to thank Glenunga for putting up such a fun and engaging debate, and we would also like to thank Nazareth for this wonderful venue, as well as our parents, teachers, coaches, and debating essays for inspiring us young debaters.